YouTube, it's Tone. I'm back with another one for you. This one here, continuation of the court survival guide. I still don't know who wrote it. His name's probably at the bottom of this shit, if I had to imagine. So, let's get into this. This is a continuation of what we were just covering here on what your rights are. Right? So, you have the right for continuance to move the case to the next stage. Motion for retrial, to retry the case based on particular court defects. The motion to dismiss and to declare mistrial should be the highest priority, and you should find every reason and every occasion that there is to use it. Even better is to maneuver the prosecutor to ask for dismissal or the judge to simply declare it. Valid reasons are lack of jurisdiction, unlawfully obtained evidence, which they do a lot. That's the fruit of the poisonous tree there. You know what I'm saying? So that's like if they pulled you over unlawfully, it doesn't matter what the fuck they find in the car because they shouldn't have pulled you over initially to begin with. So that just makes all of their evidence trash at that point. So there's a bunch of different things to take into consideration when it comes to the cases, the charges, and then the procedural defects that pretty much all these police officers are constantly doing because they're not trained in law. They just they're definitely not trained in law. So failure of the officer to appear, lack of evidence, right? So you gotta have the witness. There has to be actual victim. The cop always pretends to be the victim, and then they always switch it over to be the state, which isn't even a person. So I don't know how the fuck that works. So lack of evidence of extreme bias against the defense. Failure of the court to uphold the Constitution, failure of the court to uphold your constitutional rights, which are your property. So keep that in mind. That you're actually talking about property when you're talking about your rights. Failure of the court to maintain a fair hearing or trial, and jury tampering. Failure to maintain an impartial jury. And how they have just random ass people show up to judge you as to what's going to happen for the rest of your life. That these people never even study law. That shit is just fucking crazy in general. I don't even get it. So, because it's supposed to be a jury of your peers, people that are under the same understanding and share the same paradigms as you. They're gonna bring these fucking brainwashed weirdos that never study law to just sit there and watch this fucking theater transaction take place in a. Come on, bro. This shit is crazy. The whole, all of it is just fucking nuts. So, what is it? Number 9. So don't let them rush you through anything. If they try this, they are up to something crooked. Stop and confer with your counselors to deduce what it is. That they can just be in a rush to collect your money in the process of violating your rights. Try to expose their fraud using strategy number 6 above. So don't let them rush you through anything. Definitely take your time. If I was you, I'd probably go sit in a couple of different court cases and, arraignments, things like that. Just sit in there, so watch, so you can see how all that shit plays out. I mean, I went through it a million times, cuffed up and, sitting in the cage, all that nonsense. So, I already know what that whole process is like. So, but this can be scary to somebody who's never been through the court process. It's really just a bunch of weirdos kind of just reenacting and just rubber stamping everything and just doing everything just business as usual. They just used to raping people on a regular basis. So when they get somebody like yourself that's going to come in there, that's going to knock them out of their trance. So you definitely want to know what it is that you're doing and how things somewhat operate in there. So definitely sit in there. And then number 10, don't agree to anything that you don't understand. This is what they would quickly take advantage of you. So ask for clarification and or legal consultation with your counselors for anything that you don't understand. Number 10, objection. This is how you record the court's unfairness on the record. If the judge denies your motion, object and give your reason. If the prosecutor asks for a motion, object and give your reason. If the judge makes any decision or any ruling that you disagree with, object and give your reason. If the prosecutor says anything to violate your case of the truth, then object and give your reason. Regardless of how the case goes, you thus have your evidence on the record that validates an appeal. And you got to get that shit on the record. You got to look at it like, look, if somebody was to look over your whole case, they're not going to play them a video of how everything went. And so what they're saying is that even the voice recording that takes place in there is not valid for anything in court except for their own fucking record. So you got to keep your own record. Look at it like if somebody was to read over your case, how it would look. So all of your words are gonna end up in a text format, and you just gotta have that set up in a proper fashion to where it's gonna make it easy for you to file that as means on a appeal afterward. So keep that in mind. So number 12. So don't let the judge or prosecutor get away with interrupting you. They are just trying to intimidate you into submission and silence. Take exception to their rude behavior. You might use strategy number 6 to expose their injustice and to complete what you were saying. E.g., has the court made a judicial determination that I am not allowed to defend myself or that I cannot have freedom of speech in this courtroom? So you put it in the form of a question to put them on the spot to where they actually have to answer that question. Now they're going to make a judicial determination when they say yes or no. You're putting them right in that position because that is their fucking job. So just put them right in that position. You know what I'm saying? So put them on the spot. If the prosecutor interrupts out of turn, motion the judge to find him or her in contempt, right? Because they all have rules to play by, and they don't play by them there. So the shit is a crazy little freestyle over there is what it is. So don't let the prosecutor or judge get away with rude or offensive behavior. These are grounds to dismiss the case for the cause of bias and misconduct. If you let them get away with any offensive behavior, even a demeaning tone of voice, object to get it on the record, and to how it adversely affects your mood and composure. Rub the intimidation right back in their faces. And that's the thing is that, so nobody's supposed to be getting emotionally involved. Nobody's supposed, because it's a business transaction. That shit's fucking ridiculous. The problem is that they're not able to legally just fucking say what it is because then their whole spot's going to be blown the fuck up, right? So they have to play this stupid little fucking game in theater and shit in court to attempt to try to just play you out of your money, essentially, is what it is, without really saying it, what it is. So, I'm not a big fan of all this shit, but so that's why I don't really cover these topics, because this shit's annoying to me to begin with, honestly, because this shit's just fucking ridiculous. So, I'd rather focus more on the debt discharge and all that, because you see me, or hear me, whatever, talking about this shit is annoying. So that's why I don't really cover these topics. I don't like rehashing all of the same nonsense over and over and over again, but this shit is crucial to know anyway, so definitely keep that in mind. So what is it, what do we got? So don't let them get away with rude behavior and things like that, obviously, because that's a sign of of them being biased, because there should be no bias in any of these situations, because it is civil in nature and merely a business transaction. So nobody should be getting mad here, especially the people who are the fucking actual debtors should not be getting mad. They're not even in a position to be making any fucking demands, but they'll have you believe that they are, though. And that's the crazy part about this shit. So 14. So know when the prosecutor or judge is attempting to deprive you of your rights. This comes from paying attention to what is happening and what is being said. This is why you have your counselor sitting behind you. You will get much better at this with practice. 15. Learn to nullify the judge's lame excuses. You might hear the judge say, well, I don't have it, the law or the evidence here in front of me. When you attempt to state the proof, this is the judge's childish attempt to ignore the law or the evidence supporting your defense. So take your copy up and put it right under his nose so that there will be no what? Let's see what it is here. So there'll be no more excuse. The judge may even laugh off your embarrassing question and call a recess in a display of false authority in an attempt to change the subject when the court reconvenes. And you got to keep in mind too. So don't let it pass, it says here. So before I lose this thought, you got to keep in mind that every time a judge gets up and walks out of the courtroom and comes back in, it could be a completely different jurisdiction than you guys were on before he had left and came back in the room, right? And they'll switch people and things like that too, and those will all indicate different jurisdictions and things of that nature that could possibly have taken place behind the fucking doors. So always make sure that you clarify with them too what jurisdiction you're under and where you're picking up from, right? Because they could try to play those stupid ass games too. So keep the issue in his or her face until it is adequately resolved. Do not move until you get the answers. 16. More lame excuses you might get. I'm sorry, you'll have to talk to the legislatures about that, as if I only enforce law, or you'll have to talk to a licensed attorney about that because I can't give you legal advice. He can't give you legal advice, but he'll fucking plea for you on the bench all day before you even say what your plea is, right? He'll go ahead and enter that legal fucking. Come on, bro. So this is not the proper forum of addressing that question, or that issue is not relevant to this case. This is what you will often get when the judge knows that he cannot answer your question without incriminating him or herself. You must not let them get away without giving an answer or making a legal determination. Some award-winning comebacks are, Your Honor, am I not, Your Honor, am I not contesting the law as you suggest? Am I merely demanding that you interpret it in accordance with your own oath of office? Okay, so what he's saying here is that I am not contesting the law as you suggest, because that's what they do. They try to throw their own interpretation on what a law says when the shit is pretty, it's pretty clear. The shit's in fucking English, black and white. I don't need your personal opinion about how that shit should, you know what I'm saying? Come on. So what he's saying is that I'm merely demanding that you interpret it in accordance with your own oath of office. So that's putting them back into the law where they're going to be subject to their contract and oath and trust to the people there. So, but you have to get that shit on the record. And so that's the whole point of this, and asking them the questions in this particular format. So am I asking you, and I am asking you to do your job as referee and to identify the source of law as you are interpreting. Now, please answer the question. Your Honor, you and I both know that the legislatures and you are all part of the same legislature branch operating provisionally under Article 1, Section 8, Clause 17, and there are no legislatures here to identify the law and arbitrate a fair case. This is your job, and I'm simply asking you to do your job. Now, please answer the question. Your Honor, I am not asking for your legal advice. I have my legal counselors for that. I am simply asking you to kindly identify yourself for the court's legal jurisdiction and the nature and cause of the accusation. I am asking you to identify the code of written law which supports your ruling. I am asking you to do your job. Now, please answer the question. And then the final one here is that, Your Honor, if it is not in the forum for addressing this issue, then how can you now legally apply the issue for the first time to this case? If this is not the proper forum, then I motion the court to provide the forum required to resolve the issue before we proceed. So that's not letting them. So that's putting them in a position where they're going to have to make some type of ruling before just trying to roll past what it is that you're trying to get done, because they will. So 17, ask why. You may not always get an answer, but you deserve one, especially if your motion is denied or overruled, and you're asking will notify the judge that all the linen is likely to be aired out in your case. The judge may risk exposing some embarrassing truth and choosing to dismiss your case. 18. Catch them in the act. This is the most important reason for taking your time and thinking things through with a clear head and with your counselors. Every violation of your rights, every abuse of power, every incidence of misconduct, every disparaging remark, every subtle threat to your well-being is an opportunity to record evidence in your favor. Catching them at it, and as it happens, can easily get your case thrown out, because they have been getting away with all this fraudulent bullshit for so long that they will be surprised when they are suddenly challenged on it. And here are a few more tips to keep in mind. And that's what I'm telling you, man. As soon as you go over there with anything that they're not used to, that shit knocks them right out of their little trance. Because they're all programmed to believe that they have power too. They really don't. They just don't get challenged, so they're never really put in that position to feel that. But they will. So the judge is not the prosecutor. If he or she acts like one, then this is misconduct. The prosecutor is not allowed any more rights in legal procedure than you are. Yeah, because they're all programmed to fucking have that power too, because they really don't. And, you start breaking open their job title and, how their position even came to be and things of that nature, you can easily see that these people do not have that power. So, and they're the ones that have that fucking position. Now, how do you end up in that job and not know what the fuck, like, your job is, what your job actually is? Like, you really have to not know how to read English to even not understand what a public servant is. Like, you got to go way out of your way to think that shit's, like, how did you get king from servant? Like, you literally, come on. Like, out of your fucking mind, literally. And so everybody's programmed to fucking believe that. So how many people, you know what I mean? So think about what come on, man. Legit mind control is what that bullshit is. So, let's see what we got here. So, the burden is on the prosecutor to prove the guilty beyond reasonable doubt. Police powers, law enforcement officers, sheriffs are not intended for sources of revenue. They are there for the protection of the citizens and their property, period. And that's another thing, too, is that when these courts start to engage in commerce, they literally are downgraded from what would have been a governmental agency or authority down to a mere corporation. So they have no more power than a corporation has. Right, and so there's been Supreme Court rulings on that as well. I don't know what the case is off the top of my head, but you can easily find that. So when a judge prevents the accused from introducing evidence tending to establish a defense, the judge is making a mixed determination of fact, i.e. what happened in law, i.e. is it legal? This is also unfair. Number 19, use the semantics in your favor. So semantics is words and their meanings and definitions. So once you have done your research and homework, you will see that the entire legal systems and statutes are rife with ambiguous, deceptive, and contradictory terms of definition. So it's crazy. Ambiguous in the sense that all this shit is fucking vague and broad and fucking they try to twist it and mix it so nobody could possibly understand it. But I can, and that shit is fucking garbage. That's what I'm telling you. So you can use your knowledge of those terms, which can apply to your case, in your maneuvering concerning techniques described above. All statements, rulings, and directives issued by the judge are subject to your careful scrutiny. And because, I mean, understand that, you know, all this shit is just offers ultimately. So, and if you don't like, you know, so even a judgment is really an offer. That's why it needs time to cure and shit like that. That shit ain't just fucking because he says it that shit is a wrap. Absolutely not. It's really a commercial transaction, which are all subject to Uniform Commercial Code, and all of these shits need time to cure. So at least 72 hours. You're gonna definitely have that to be able to fucking reject that offer and return with a what do you call it? Counter offer. Right? So, and legal implications don't budge away from it until it is completely resolved to your satisfaction with a judicial determination. Hang them with it. So, number 20, additional useful information. Know your rights and constitution, the state constitution to be clear, right? So I'm going to just get that shit clear for you. It ain't the fucking U.S. Constitution. It's the state constitution. Read that. So to empower your confidence and authority, not to argue about it. Declaration of Independence, Part 2. Governments derive their just powers from the consent of the governed. Without the people's consent, the law is unjust. Okay? Real fucking... That's black and white English right there. Come on. So, Declaration of Independence, Part 2, when a government becomes destructive, it is the right of the people to alter it. I think it's the duty of the people to alter it. I mean, to be fair, that shit is your fucking duty. Because who else is supposed to do that shit? Who else is supposed to do that for you? So, allowable jurisdictions given by the U.S. Constitution, Article 3, Section 2, the judicial power shall extend to all cases in law, common law, equity, and admiralty jurisdictions. So... and those are all contracts, mind you. Really, I mean, everything is contracts, so know that. Which, I mean, it has to be because they're all fucking businesses. So unless you can't just slide in somewhere as a fucking corporation and just start doing business. You have to apply, register, and things like that. And they did all that. You know what I mean? So anyway, also applicable is the general statement made in Article 4, Clause 2 of the U.S. Constitution. The Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution, no law passed contrary to this Constitution shall have any validity. And that's what I'm telling you. If there is a conflict, the state loses. So that's the thing, is that, you know, they're only allowed to write these unconstitutional codes and statutes because they are just that. They're corporate policy for their businesses. The shit does not apply to you. You know what I'm saying? So Amendment 1, Congress shall make no law abridging the freedom of speech, the right to peaceful assembly, and the right to petition the government for a redress of grievances. Amendment 8, excessive fines and penalties shall not be imposed, right? And that goes with bails and all that shit too. So Amendment 11, the judicial power of the United States shall not be construed to extend any suit in law or equity commenced or prosecuted against one of the states by citizens or subject of any foreign state. This means that once you can prove the prosecutor and or judge are citizens of a foreign state under the title of nobility, the case cannot be prosecuted against you as the state, right? Because they're trying to declare the state as sovereign, which is essentially going to be a fucking a title of nobility, right? So, but in all reality, everybody's fucking sovereign. So if you're going to sit here and say that shit, you're essentially implying that nobody else is but you. You know what I'm saying? But everybody is. Everybody's born sovereign and shit. You have to literally forfeit that in order to to not have that shit actually be a fact anymore. You know what I mean? If that makes any sense. Maybe it doesn't. Let me see what this is. What do we got here? So the burden is on the prosecutor to prove guilty beyond a reasonable doubt. Oh, actually, we just fucking ran through this right here. Let me get to the next one. The member of the sovereign body of we the people can show that the court is operating outside of its geographical venue, i.e. District of Columbia. So, you know, the U.S., as people know as the United States, is sitting on America. So the U.S. is kind of a territory, basically a leased piece of land that was allotted to these people to conduct business and shit. And they do this in every country. They fucking do this. And then so that's why they can do whatever they want within that 10-mile square. And then they try to subject or contract with people in order to get them to be subject to their corporate policies and shit like that they call laws. You know what I mean? So, and is therefore a foreign state. So District of Columbia is a foreign state. It is. And that's why you're foreign to them, because they're foreign to you. Okay, so UCC, Uniform Commercial Code 1-103.6 commands that the courts to retain common law rights and remedies, and the statutes must then be construed in harmony with the common law. The code is complementary to the common law, which remains in force except where explicitly displaced by the code. So everything has to be based on the paradigm that the Constitution was written in, under the same context or pretext. So standards, guidelines, and things like that are all going to come from there. So you can't write something that's outside of harmony with that. So there is a law somewhere stating that the question of jurisdiction may be raised at any point during the case, even from prison. No data yet, though. So facing the judge and prosecutor, the attitude check right here, apparently. I guess you got to check their attitudes too. So... what is it? So continue with your breathing. Remind yourself that you are sovereign, intelligent, well-informed, courteous, polite, responsible, honest, and free. You are a smart sheep, prepared to outwit a... I don't even think these people are even that sharp, to be honest with you. I'm not talking about the sheep. I'm talking about the wolf. You know what I mean? So, but I guess you don't got to be that smart when you got sharp teeth. Now do ya? So you are here to help the court recognize the errors of their ways, but only in the process of getting out of the system ASAP. You are politely, calmly, but steadfastly standing up for your rights despite their efforts to strip them away from you. By your efforts to keep asking them questions, you are committed to truth, justice, and your sincerity to heal the old system. Try to keep your thoughts and vibration as positive and well-wishing as possible, but sternly asserting your rights. You are not here to buy into any reaction to any guilt trip or shame wrongdoing that the nice prosecutor or judge may try to establish. Better for you to raise up the condition of the court than for the court to drag you down to their lower vibration. It will probably take some practice before you master this. Not to worry, no one is expected to perform perfectly their first time. Many patriots and sovereigns are effectively using the lower traffic courts for their experience and education, preparing them to win for bigger cases in higher courts. For now, you can think that the court and your information sources for your valuable education while you get an on-the-job experience. The sequence of court appearances. Remember, unless you are the prosecutor plaintiff going after a public official, your first priority is to get the case dismissed or thrown out with the fewest court appearances. Ideally, you would like the judge to dismiss your case with the first few questions, such as that he or she will never have to see you in court again. There is no reason to personally go through all of the issues and arguments unless you want the experiment. So it is generally best to bail out with your win as early as possible. So if you go all the way to trial, you must be prepared to formally prove your innocence or disprove your guilt, possibly in front of a jury. And then if you lose the case, you will have to go all the way to appeal in order to win the game. So therefore, the record, the full range of sequences of appearances is represented by the maximum minimum. So let's see what we got here. Arraignment, required arraignment. So special appearance, plea bargain hearing required, motions hearing, pre-trial conference, trial, sentencing, retrial, motions hearing, appeals hearing. So these are all different dates that you're going to end up having to deal with at some point if you go into court. So half of all these appearances are one of which you would initiate yourself because the court does not want to drag out your case. All the court is interested in is arraignment, your plea, trial, and sentence. Sometimes two or more of these appearances are combined. The court simply wants your money with the least amount of time and expense on their part. If you have difficulties asserting your rights and following the guidelines, or if the judge, prosecutor are particularly shrewd in manipulating you or your case, then they will probably have to go all the way to appeal in order to win your case. Rest assured that the appeals hearing is the most difficult to prepare for, cost-wise and paperwork-wise, but certainly not too difficult to handle by yourself with your counselors. Still, it is much better way to win, right? And to not have to go through it. So the following description of sequential court appearances contain applications for the general guidelines listed above. We hope that you enjoy them. We sure did. Where applicable, we have included examples of some of the paperwork that you would need to generate on your word processor, PC, personal computer, or other freedom machine. So first, court appearance arraignment. This is the most important step to take, and hopefully the only appearance that you will need to make. The court is required by its own rules to hold an arraignment. If they conveniently forget, then you must demand to hold one. If they deprive you of this procedure and begin prosecution, they have committed a much more serious crime beyond the scope of this guide. And that's the thing, because they need your consent to move forward. So that's what the arraignment's all about. So purpose. This is the initial appearance written in your citation or summons complaint form from the officer. Somehow you have agreed to appear to answer the officer's charges against you. The purpose of this arraignment is to present the charges and to find out how you intend to plead or deal with them. They are testing whether or not you will stand up for your rights or act guilty or afraid like most people. The court is set up to make it real easy for you to plead guilty, to pay your fine, to then leave in fear and ignorance. However, there are still many ways that you can win the game. And the game is the key word here. This shit is a fucking game. So, it is a game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.